We the people begins the United States Constitution, which went on to spell out a whole new order for the people, at least those lucky enough to make it over to this side of the Atlantic and in between the then designated borders. Not a democracy. They didn't, most of them like that word, at least not yet, but a republic that had elements of democracy, rule by the many people, the majority rule. It had elements of democracy in a representative form by the standards of the late 18th century and arguably by the standards of the people in ancient Athens who invented democracy, and we get the term from them, the rule by the many. Arguably a more extensive democracy already in those decidedly undemocratic days by our standards than they had in ancient Athens. But the people who were, in whose name the Constitution was written and for whom it was established, were not defined in the Constitution. And again, I'm going to leap forward just to give you a sense of where this all heads. I mean, it heads, of course, to today, but I want to describe the trajectory from the Philadelphia Convention, the writing of the Constitution, 1787, and the ratification a couple of years after, to 1868, when the Constitution was rewritten from top to bottom and reconceived. The question of personhood, what it means to be a person, and how a person relates to the people, the sovereign people who claim sovereignty and surprisingly survived all those years up to the Civil War, and then more surprisingly perhaps survived that war and reconstructed themselves by hook or by crook. Reconstruction wasn't over yet, hadn't been undone yet in 1868 when they ratified by constitutional provisions the 14th Amendment. They revisited personhood, and I mentioned in the previous iteration, previous lecture about this, what they did with the term citizenship. But they also monkeyed around with the term person, and expanded and altered its meaning and its relationship to the term citizen in the 14th Amendment, ratified by the states in 1868. I mentioned that the 14th Amendment in 1868 declared in its first line all persons born or naturalized in the United States to be citizens of the United States. And that's radical. I mentioned that was controversial and provocative, revolutionary, really. The world changed radically on the battlefields, and now the Constitution was recording that change and preserving the meaning, at least as Republicans and others who were on that side in the Civil War understood the meaning of the Civil War by saying that all persons born or naturalized in the United States are citizens of their states as well as the United States. But it did a lot more. And the parts of the 14th Amendment that became controversial had to do with what the 14th Amendment did to the term person. And it did a couple of things. First thing it did, maybe not so obvious, it's already done in that first sentence, by changing the meaning of citizenship to all persons born or naturalized in the United States. It has changed the meaning of the term person in its relationship to citizen, because there used to be a much wider gulf, a much bigger distinction between, in that Venn diagram of persons, human beings, and citizens. Now, citizen had expanded to include a heck of a lot more of those human beings. those born or naturalized in the United States. Obviously, what they're talking about are the 4 million people who were liberated by the war, not entirely liberated by the Emancipation Proclamation, but constitutionally liberated from slavery in 1865 with the ratification of the 13th Amendment, which also, interestingly, did not become as controversial as people thought it would. But the 14th Amendment and those provisions of what it does to personhood do become controversial, and they become controversial because they are no less radical, no less revolutionary than what the 14th Amendment did to the term person. In addition to changing the relationship of person to citizen, the 14th Amendment echoed the 5th Amendment with a twist. The 5th Amendment, you remember, part of the Bill of Rights, basically the original constitutional package deal that the people got when they bought in to the gamble, the sweepstakes, by ratifying the thing. The 5th Amendment said, no person shall be deprived of life, liberty, or property without due process of law. Now, they didn't exactly define what due and process meant, what law meant, and again, they didn't define what person meant. But it was clear that the Constitution refers to persons and it refers to citizens, and they are not entirely synonymous. That was just in the structure of the language used in the document from the beginning, and still in 1868. Persons have more rights, have a different range of dignity and respect that they are due in the Due Process Clause. They deserve in some fundamental philosophical constitutionalizing way. They are constituted in this republic, in this new order of the ages, as they called it, to have rights that extend far beyond those of mere citizens. And now, those persons are not just having their rights of due process re-established or reasserted after this terrible, unsettling Revolutionary War. More revolutionary in some ways, at least when they got through changing the Constitution, than the so-called revolution that came before. That was called the Revolution and still is. The Revolution. Due process rights were explicitly transformed to apply to the relationship of persons to their state governments. And the Supreme Court had taken that, it's a lesson all good teachers love in the hazards of the passive voice. The Fifth Amendment says, no person shall be deprived. Deprived by whom? Now, who was going to do this depriving? Well, we had the case of the civil rights cases in 1883. It's hazardous. Even when Congress turned it around in the 14th Amendment and used the active voice, it still could be limited and compromised. But in 1868, Congress and the people were declaring that now state governments, make no mistake about it, whatever you want to do to these former slaves in your states, you cannot violate their due process rights. If you take life, liberty, and or property from them, which governments do, that's what governments do, state governments, national governments. These are not naive, starry-eyed flower children who write this thing. They are realists. Governments take property. They take liberty. They put people in jail. They send them off to get killed or kill in armies and get maimed and brutalized in wars. They take people's liberty. They also take life. Probably took a lot more life in those days, even accepting the war, than they do now. Texas and Virginia and Oklahoma are doing their best to live up to those old standards of taking life. But governments take life. That's understood. But they're not going to do it just when they feel like it. They're not going to do it arbitrarily, the way the British Empire used to do, and the way some people maybe did during the war. They're not going to arbitrarily come in. You have a process that you have to that you can put the government through to, if they pretend, state government or federal government, to take your life or your liberty or your property. That's one thing the 14th Amendment does. The other thing, even more radical, the last thing it does, it creates human equality as far as constitutional law goes. People are surprised to hear this, but the word equality, the concept of human equality is emphatically in the Declaration of Independence. Jefferson wrote, and a lot of people rallied to the banner of the Declaration of Independence, which says all men are created equal and endowed by their Creator. This is a natural right of human equality that Jefferson asserted, and people seemed to believe when they revolted wildly, rashly from their monarchical imperial overlords in what became a war of independence. But when they got around to writing the Constitution, they left that part out. The concept of equality, the word equal, appears in the original Constitution one place. Anybody want to remember or guess? Equal representation of states in the Senate. That is one of two provisions of the original Constitution that is so fundamental and important that it can't be amended. The Constitution says this thing can be amended, it can be changed. But one thing you can't amend, one thing you can't change is the equal representation of the states in the Senate. That's equality, not for persons. Now in the 14th Amendment, as Professor Shoemaker mentioned, persons have equal protection of the laws. And the states, not just the federal government, but the state governments have to give them equal protection. Now, I mentioned the word corporation. This is just one example of the meaning of life that becomes controversial. Do corporations have rights of persons? You've heard this in recent years. It is not, as some people might think, an entirely radical, out of left field, maybe right field idea, though who knows. It does have a provenance, and it even has a provenance in constitutional law, though not in the Constitution itself. Not in the 14th Amendment, not in the 5th Amendment, not anywhere else in the Constitution. The word corporation does not appear in the United States Constitution. The word person appears in the original Constitution, including the Bill of Rights, 26 times. 3 of those times I mentioned, it clearly means slaves. That's one kind of person that is clearly included in the term person, slaves. The word citizen in the original Constitution appears 11 times. It's not clear, who is included in that smaller category. The word corporation does not appear, and it's not because the word corporation didn't exist. It's not because the framers of the Constitution, the authors of the Constitution, weren't thinking about it. They were. They discuss in the debates over the writing of the Constitution, they discuss corporations. It was clearly a power that belonged to government. They're going to create a state. They're going to create a new order. They're going to create a government here, a strong government. And strong governments have the power to delegate pieces of their sovereignty, to sort of portion off their power to something else. And they do it by calling it a corporation. The government itself actually is a corporation in the common law that evolves from Metz, the 12th century in England, a system of administration of justice independent of the church, the common law, a system, as the revolutionaries in what became the United States saw it, a system of special privileges that was rigged for the king and corrupt courtiers in Parliament who handed out special favors and used their governmental power, exploited illegitimately the powers, the sovereignty to create special powers for themselves. The word corporation was there. It was there in the common law. Blackstone, William Blackstone, William Blackstone, codified the common law in the middle of the 18th century before the Revolution, and he had a whole chapter, I think it's chapter 15, on corporations and how they related to the British Empire, the British monarchy, and the system of law, the rule of law that they had evolved and that he was codifying. Well, they left it out of the Constitution. I mentioned because they didn't want the Constitution to be controversial, and corporations were controversial. The British East India Company was a glaring example of a corporation. What did they mean by corporation when they left it out of the Constitution? They meant things like the British East India Company, but they meant a whole heck of a lot. We don't know. They didn't have an awful lot of debate. It wasn't ever debated on the floor among the whole convention. It was debated in 2 different committees and recorded in the record. One of the tasks of my research is to try to figure out from other records involving the authors of the Constitution and the people they hung out with and the people who sort of influenced their ideas, what they meant by corporation and what they were thinking when they left it out. Take another popular document, it was popular then at the time, written the same year the American Revolution, published in 1776, The Wealth of Nations by Scottish moralist and political economist, founder of modern political economy, or economic science as people sometimes call it now, Adam Smith, uses the word corporation all over the freaking place in his book, The Wealth of Nations. And it's a very negative connotation. It was a book that was popular among people who didn't like the British Empire because it was a book that intended to undermine the mercantilist policies, the trade policy, basically, of the British Empire, which Adam Smith was trying to convince Englishmen, literate folk, educated folk, that their wealth was being compromised by mercantilist, protectionist policies as we would see them today. He uses the word corporation all over as part of the problem. He doesn't like corporations. Interestingly, if you read him in context, he seems to be talking about municipal corporations, not business corporations as we would understand the term. And one of the mysteries of the history of corporations and corporate law is that England has already had an industrial revolution around the time that the 1750s, around the time that Blackstone was publishing his volumes codifying the common law, that very strongly influenced the people who wrote the Constitution, more than it influenced the guy who wrote the Declaration of Independence. The common law codified by Blackstone was codified in a period when the Industrial Revolution was already happening, the first Industrial Revolution, already happening in England. And Smith wants the revolution to happen. He sees all sorts of sad consequences of that. It's going to turn us into brainless potatoes in some ways, but you know, it's a good thing. He wants it to happen. It's going to make us wealthy. And that's a good thing overall for Smith. But corporations rob people of the ability to compete freely, to trade freely. Municipal corporations, which built literal stone walls, built walls of restrictions in corporate charters as municipalities, claiming a piece of the king's sovereignty given to them as a justification for barring entry into various kinds of trades that the municipal authorities deemed were important to the wealth or the health or just the privileges of the people that they hung out with within the bounds of their municipality. That's why they leave the word corporation out, probably. They didn't want it to be controversial in that particular way. That's going to change too, not with the 14th Amendment. I have time, I think, to talk about one step. In 1819, Justice Marshall, who didn't much like Adam Smith, who sided with Alexander Hamilton, who sort of occupies the polar opposite in the understanding of public trade policy and the relationship of the government to what we would call entrepreneurship. It's another word they didn't have, not even in France in the 18th century. The relationship of that to the state, to the government. Alexander Hamilton and John Marshall, his fellow Hamiltonian, did not want a completely free trade economy, not by a long shot. And they wanted to enshrine in constitutional law certain kinds of restrictions and protections, and one of those evolved to be protection of corporations. Problem was, since the Constitution, the authors of the Constitution effectively left the power to create corporations, it's not like they thought it was going to go away. It was a constituent element of sovereignty. Sovereign powers, governments are gonna, as much as they're going to take life, liberty, and property, they're going to delegate chunks of their sovereignty to municipalities and other bodies that they will constitute as corporations, answerable to them. The state governments were going to do that. That's what they were doing when they left it out of the Constitution. They were leaving it to the state governments. And lo and behold, most of the corporate charters to this day are created by, well, Delaware for 20th century reasons. But the original plan was that all states would sort of create corporations, and they still do, though most of them are created by Delaware. In Marshall's day, the corporation was not a part of constitutional law. It was part of common law. And what he does is he imports from the common law, which many of the revolutionaries, including some very vocal sons of the revolution, grandsons of the revolution in the state of New Hampshire, where Dartmouth College was and is, believed that the revolution was meant to overthrow the yoke of the British Empire, of those mercantilist policies that robbed otherwise free men, sturdy, striving, aspirationally Republican men of the fruits of their labor. That's what they believed the revolution was about. And when the king chartered a corporation, Dartmouth College, basically to train ministers in downtown New Hampshire, that charter was challenged after the revolution, and that case went to the Supreme Court, and the revolutionaries, at least people who interpreted the revolution, lost their battle, and Marshall decided that the corporations were going to survive. They were going to survive a challenge by a Republican, popularly elected government in New Hampshire saying, we are nullifying or altering this corporation that was created by the sovereign, formerly sovereign king, whose yoke we've thrown off, along with this nonsense about divine right and all the heritage of corruption and special privileges. We want that. If I want my kid to be a minister, I should be able to send him to Dartmouth College just like the privileged people who've been using that institution all along. We are sovereign. We, the people, are sovereign. Now, that was a claim that they made. They lost the case. And Marshall had two problems. One, corporation ain't in the Constitution. How can he recognize a corporation in law? You come in to the court, the federal courts created by this new order under the Constitution. You can either be a government or a person. Otherwise, you can't be here. If you're going to sue somebody, you actually got to be a citizen, not just a person. But if you're going to be here, you got to be a person, or you got to be a person representing a government. Foreign government, state government, federal government, whatever. Person. Obviously, this Dartmouth College is a piece of paper, a charter written by the king decades earlier. How can it be here? Well, it can be here because it's actually, presto changeo, it's a person, just as Blackstone said it was. And those are not Marshall's exact words. He doesn't say presto changeo, he doesn't say, but he does sort of say, if you read his language, I've sort of got a problem here, guys, bear with me. I got to call it something, and I could call it a government, and there's actually a very good argument for calling it a government, because it is, after all, delegated by the government, created by the sovereign power to express or carry out certain sovereign functions for the benefit of we the people. But he goes the other way for reasons that remain obscure to this day and calls it a person. The other problem he has is, again, there's no Constitution, so what the heck is he going to stand on in the Constitution? What he does is there is a clause on contracts, and he decides that this was a contract, that the king made a contract with the trustees and their successors, their sons and grandsons, who are now defending their version of Dartmouth College in this new environment of sovereignty of the people. And Marshall wants them to win, and he has to find something in the Constitution. So he uses the contract clause, and the Constitution is very clear. It says, Congress, don't have the exact words, shall make no law impairing the obligation of contracts. There's an obligation, there's a contract. That was the end of the case as far as he was concerned. It's not the end of the case or the engorgement of the concept of the corporation and corporate personality. That continues. Big turning point in 1886, where far beyond the idea of Justice Marshall, a new Supreme Court decides that when you have that word person in the Equal Protection Clause of the 14th Amendment, lo and behold, we're going to include corporations. It had never been understood that way before. Marshall was pretty clear that he did not think that every time the term person came up in the Constitution, you could just throw corporation in there and it would have all the rights or immunities or obligations of a person. Couldn't qualify for office, couldn't be naturalized if it was a foreign corporation, couldn't run for when the Congress is empowered and required to conduct a census counting all the persons. It's not going to count corporations. It's going to count slaves, remember, and then multiply by 3/5 for each one for purposes of apportionment and taxes. But it's not going to count corporations. No way was that going to happen. Marshall did not go that far. He was just trying to get through the day and deal with this rather messy problem on his desk that wasn't going to go away. Corporations created by the states were going to sue and be sued. They were growing, they were increasing, and they were increasingly used for business purposes. How that happens is a story you probably know something about. It's something that I may get a chance to speak with you about at some future point. But that's the beginning, and that's how corporations became people and thereby changed the meaning of life.
Freedom 101 is made possible by generous support from the University of Oklahoma Alumni Association. Freedom 101 is a program of the Institute for the American Constitutional Heritage at the University of Oklahoma. For more videos and podcasts, visit freedom.ou.edu.